Good afternoon, everybody. We'd like to welcome you to the last in the Labor, Employment, Human Rights Group at Fasken's Year in Review seminar series. Today, we're here to talk to you about all that's new and interesting in the world of collective bargaining. There's certainly a lot to talk to because there's been a lot of activity this year. But we'll start off with some introductions and some administrative items. So first off, I'd like to introduce you to the panel. Joining me today, first, my name is Ian Campbell. Joining me today is Andrew Dixon and Karine Fournier. We are all partners in Fasken's Labor, Employment, and Human Rights Practice Group. I'm based in the Toronto office, Andrew's based in Calgary, and Karine is based in Montreal. And I'll let them, they can give a little bit of introductions for themselves, but our practices are all very similar in that we're out there doing collective bargaining, advising on collective bargaining, and dealing with the aftermath of bargaining sessions that do not go well. And so we're going to try over the course of the next 90 minutes to use our practical experience and what we're seeing out in the market to give you a scene set of what's going on out there, both in terms of what's happened in the year that's just concluded, but also maybe trying to give you some insight as to what we can expect in the year ahead. So with that, a few other administrative items. If anybody needs closed captioning, there's a button at the bottom of the screen that will enable you to access that. Materials for the presentation can be downloaded on the Materials tab. To the extent that anybody needs technical support in any way through the session, you'll see that there's a tech support button on the bottom of the video pane, and you can click on that button and get whatever help you need. And to the extent that anybody has questions, there's a question tab at the bottom. We'd encourage you to sort of submit them as we go. And to the extent we have time at the end of the session, we'll try and get through as many of those questions as we can. And then finally, you'll see that on the also on the bottom, there's a survey tab. We try and make these sessions as topical as we can. We try and make them as useful as possible, but we really do welcome your feedback in terms of what you liked, what you didn't like, what you'd like to see in the future. And so we'd encourage you at the end of the session to just take a moment or two and please complete the survey. It helps us to sort of improve our product deliveries for the future. So if somebody be able to flip ahead, we'll start diving right in. First, I'll just give you a little bit of an overview in terms of where we're headed. We're going to start off today by giving you a little bit of some trends, what we're seeing out there in the market. Once we've sort of talked about that a little bit, we're going to give you some specific case studies from significant settlements and labor disputes that have taken place so far in 2024. One of the trends we're going to be talking to you is the fact that not everybody's been able to get a deal. And there have been numerous incidents in which the government has had to intervene to end disputes and put people back to work. And we're going to talk a little bit about that and the impact we see that having on the bargaining landscape as a whole. And then once we've gotten through that, we're going to spend a little bit of time telling you what we think you're going to see coming your way in 2025 before concluding with a little bit of tips, just tips and tricks that you can use in the course of your negotiations and your collective bargaining. So I'll start off a little bit with just sort of the current scene. And I think it would be fair to say that it continues to be a challenging environment for employers to collectively bargain in. Not quite as bad as 2023. I think there has been a little bit of improvement, but it's still really tough. We're seeing continuing to see an upward pressure on wages. And while inflation has dropped, the effects of the inflation that people experienced in 2022 and 2023 are still there. The people that we're negotiating contracts for in 2024 probably haven't had a chance to renegotiate since 21 or 22 before that really took effect. And so even though it's eased, we're really still seeing the lingering effects of the fact that people's wages were not keeping up with the increase in their costs due to inflation. And so people are looking not only to get wage increases that will take them forward, but to make up for what they've lost in the years that have passed. And so we're seeing a continuation of a lot of the same patterns that we spoke to you about at our year in review seminar late last in 2023, in which we're seeing this employee frustration over the decrease in their spending power, resulting in very aggressive tactics by the unions that represent them. We are seeing wage demands and increase requests that are far in excess of anything we've typically been used to, and we're really seeing an environment that's unlike what we've seen in at least the last 30 years, maybe as much as 35. So it's continuing to be a very challenging environment. And what that means is that not as many people are getting deals done. And so that's led to a significant uptick in the number of labor disruptions and work stoppages. So a little bit about what's driving some of this employee frustration or perhaps the erratic behavior that we're seeing. Well, it's difficult to put your finger on it because it can be different in every situation. But I think what we're really seeing is just frustration about the fact that it's a difficult time for a lot of people. Okay. Employees are mad about everything that's going on, the uncertainty of the world as it currently exists, especially in light of election results of the not too recent, not too distant past. They're concerned about inflation, about the security of their jobs in the economy, and the effect that that's having on them. And so there's this tension, this frustration, and we're seeing this being vented at the bargaining table. And at the same time that we see that happening, there's been a shift. A noticeable shift, not in every case, but holistically overall, in terms of unions, who's running the unions and the relationships we're seeing between the unions and their membership. And the unions are having an increasingly difficult time. I was going to use the words talking sense, but that's not the right phrase, but basically controlling and funneling some of this anger in a productive way. What we're seeing is instead of going through and saying, okay, we understand you've got 12 things you'd like to see. Well, one round of bargaining, we're not going to be able to get you everything we want. Let's prioritize these things. We'll be reasonable about putting demands forward, knowing that it can't all be dealt with at once, and we'll proceed in that way. Instead, we're seeing a situation where everything, the whole kitchen sink's being thrown on the bargaining table. There's much less of a willingness to prioritize. You're seeing many more proposals on everything from work-life balance to scheduling, all manner of non-monetary items, hybrid work policies, remote work. Many of these topics we're going to get into in a little bit further detail as we go through today's session. And then once employers have run their way through that difficult gauntlet, they then get hit with, oh, and we want massive monetary increases as well. And then even if you can make your way through all of that and get to a recommended settlement, employee populations, it's not like it used to be. Union comes forward, they say, we've got a good deal, we're strongly recommending it. Of course, it wasn't a guarantee, but most of the times you'd get it through. We're seeing that's not really as much the case anymore. We're seeing a situation where the membership doesn't value the recommendation of their unions nearly as much. And to a certain extent, sometimes it feels as if the inmates are running the asylum. And so is that due to a generational change? Is that due to some of the other factors we've just been speaking about? It's difficult to pinpoint. And of course, every situation will be slightly different in terms of the dynamics at play. But we're seeing lots of very good settlements be rejected. And these are things you now need to be prepared for in a much more organized fashion. So we talked about all of these factors, this frustration, this tension. It's resulted in an increase in labor disputes. The graph you now see on your screen sort of tracks data. And it's not perfect data, but it gives you a good sense from 1946 to 2023. On the left-hand side, it's person days lost due to work stoppages. And on the right side, it's hours per 1,000 employees. But what we sort of see is that, putting the mid-70s aside, when everybody was at war, there was a little bit of an uptick in the mid-80s. But since about 1990, there's been a period of relative calm, especially in the period of 2006 to 2020. And that's the environment in which we've been bargaining for decades. And the environment to which many of us had gotten quite used to. An environment in which you put reasonable terms on the table, you work through the issues, and you were most often able to get a settlement that was recommended and move on. But there's been a drastic change. You'll see on the right side of that graph that the data, as we came out of the pandemic and everybody got back to bargaining in 2022, the numbers have gone back up the chart. We're now sort of back at a level that's more akin to sort of the spike we saw in the mid 80s. And in 2023, there was 6.6 million person days lost to labor disputes, right? That's huge, especially compared to what we'd been used to in the past. That pattern has continued into 2024. And we don't have full data for it yet. It's a little bit early for that, but we can. And you just know this by looking at the newspaper and the headlines that you see, week in and week out, about another major dispute coming to an impasse or coming to a deadline, if not yet a work stoppage itself. And nowhere has this trend been more prevalent than in the province of Quebec. So maybe I'll now turn it over to Karine to give some flavor about what's happening there.
Yes. So with my lovely French accent, my perspective on the Quebec dispute, as you can see on the screen, the same trends is occurring in Quebec and maybe a little bit more, as we always have our Quebec unicity. This is maybe more unique, but we do have more disputes in Quebec the last couple of years. If you see on the trend, it has been lower and lower from beginning of 2000 up to 2019. You see it's coming very, very low, below 50 number of disputes in 2020 because of the pandemic. It was kind of a shame for the union to go on strike at that time, so we had almost no dispute at the time. And since the end of the pandemic, you can see the chart going straight up. And as it stopped in 2024, we have already 180 conflicts back in November, and it's still going on. So I'm quite sure that 2024 will be even more than 2023 in terms of a number of conflicts, labor conflicts. So this is what happened when the negotiation doesn't go as we expect. And as you can see on this slide, usually in terms of average, we had no more than 50,000 hour loss for strike and lockout per month in the last 20 years. And last year, this figure was up 4 times by 225,000 hours lost. So it's not just that we have more disputes. These disputes last longer than before. So this is why you need to pay attention to this training, so you can be prepared with your contingency plan and all the tips and tricks to try to prevent and avoid those disputes. In terms of wage settlement trends, I'll try to go slowly because there's a lot of numbers on this slide that are very important if you are negotiating your wages right now or in the upcoming year. Good news is that in the average, the settlement in 2024 are a little bit lower finally than the 2023 in terms of average. We see an average of 3% per year compared to 3.5 in 2023. If we exclude public sector, it's a little bit higher, so 3.8% in 2024, but about the same difference back in 2023, it was 4.3%. If you go to negotiation, it's still the first year of the contract that hit the most. The average of the first year is still higher than the rest of the CBA of the contract. So you can see on the chart, first year average of 3.4 compared to 4.3 in 2023. So, of course, some industry are hit more heavy than others. So we can remember last year the Ford contract or other specific industries contract that were very much higher than other collective bargaining negotiation. But it's still the first year that is hard to negotiate this 2024, and it most likely will still be the trend in 2025. But I don't know if Andrew and Ian will agree, but I think next year will be a bit lower again, because now that the inflation is more stable, union will have less and less argument for a higher first year. Back to Ian. Andrew, sorry.
So just jumping off that point, what we can see here is exactly what Karine's saying when we're talking about inflation and wage increases, because the fact is that wage increases follow inflation. It takes time to catch up, and that's what we're working through in all of these new collective bargaining meetings. Just on the top, for example, here you can see that this is in 2022 when inflation was at its peak, and the top line here is the consumer price index. And you can see we're looking at inflation rates of between 5 to up to almost 8%, while at the same time, wage increases were much lower. We have wage increases between 1 to 3% that we're tracking through 2022. This then started to change in 2023 and 2024 as wage increases then started to outpace what the current inflationary rates were. We have here, you can see inflation started to be closer to 2-3%, but the actual wage increases were 4.2, 4.3, 4.7% in the public sector, slightly lower or higher depending on the month for the private sector. But ultimately, what we're going to hopefully be seeing is a closer alignment as inflation starts to come down and as things start to stabilize a little bit. But of course, like Ian said, a lot of these agreements, previous agreements that are coming up for renewal and coming up for collective agreement, were negotiated at a time when inflation and wage rates were at a much lower percentage. So while the rate of inflation has slowed down, we're still dealing with a big gap between the cost of goods and a cost of living versus where wages are at. And we'll talk a little bit more about that when we look at some case studies. So setting aside wages for a moment, one of the other big trends that we saw in bargaining in 2024 was, of course, remote work and hybrid work environments. Coming out of the pandemic, employees and employers are struggling with back to the office. There's some studies that have shown that almost 80% of workers who experienced work from home during the pandemic want some sort of hybrid workplace. So there's obviously a big demand on employees wanting some flexibility with their scheduling and with remote work. And we see this in the news with non-union employees all the time, with large companies bringing their office staff back to the office and the issues that that's causing. But now it's coming into the union environment as well. And it makes sense from the employee's perspective. There was a lot of flexibility. There was a lot of cost savings. There's a lot of things that made life easier for employees who were able to work remotely. But from the employer's side, of course, I know lots of your businesses are dealing with this as well. There was a gap between collaboration and culture and oversight and management. And of course, both sides have argued that it's more productive to either work from home or work in the office, or maybe in some environments, it's both. But because this is a big push for employees, it's of course a big push for the unions in collective bargaining. And so unions are now pushing for the right to work remotely in collective agreements. And this is because at this point, subject to anything being in collective agreement, it's going to be a management right. And of course, if it's a management right, there's going to be reasonable discretion that the employer is going to have to recall employees back to the office, to set their own terms for hybrid work environments. Unions want a bigger say in that. And so we now have a lot of unions in the context of administrative employees or technical employees who are pushing to have telework agreements included in their collective bargaining, in the collective bargain agreement, either as memorandums of understandings or put into the terms itself. And so it's accelerating what we find some of our clients thinking about what they want their workplace to look like, because as soon as we put in the collective agreement, it's going to be hard to remove it. And so we're having lots of discussions with our clients now about what they want their workplace to look like, how work from home's been going, where the right balance is, because ultimately, if there's something that gets agreed to, it's going to be difficult to change. And of course, one thing to also highlight is from the federal space, there is the ability for employees in union and non-union work environments to request flexible work arrangements. And we're seeing more unions grieve these denials of flexible work arrangements. For those who don't know what a flexible work arrangement is, the Canada Labour Code allows employees to make requests for flexible work arrangements based on hours of work, location of work, or schedules. And there's only very narrow grounds for an employer to reject those. Essentially, the request has to result in additional costs, or it has to affect the performance or management of the company. And so unions are using these strategically now to have in federal spaces to have employees get the work from home policies they want. And in some cases, I've had unions try to make broad-based demands for flexible work arrangements for all of its workforce. Now, we've taken the position that that's not consistent with the purpose of the Canada Labour Code and that these are individual requests, but it's definitely a trend that's been coming up. Similarly, other noticeable trends that we've been dealing with in the last year is unions are now pushing for longer deals. And if those offers are noticeably higher than prospective inflation. So unions want to have longer deals so they're not getting back to bargaining and they're getting the increases they want over a longer period of time. And specifically, unions are now looking for signing bonuses in one form or another. And this is a way to make up those lost wages that lots of employees feel like they missed out from that change from when inflation was low and cost of living was low to when it's increased in the last couple of years. One thing that I've definitely experienced is that there's no longer any early settlements. Deadlines are required to get anything done. And I think this goes back to a lot of what Ian was talking about, where we have, one, a lot of things on the table. There's a lot of things to get through. There's a generally angry employee base, or not angry, but a demanding employee base who want results. And similarly, it's taking that time to get union leadership to agree to anything that they feel comfortable putting to their members, because there is some hesitation with coming to deals that then ultimately don't get ratified, which we've seen a number of examples of this year. But ultimately, like anything, the experience is still broadly the same, that cash is king. So ultimately, wages are always going to be the biggest issue. And something that is creeping back in, which is a blast from the past, from that chart that Ian showed earlier with work stoppages from the 70s and 80s, is the return of COLA. So the return of cost of living adjustments. And a cost of living adjustment is pegging wage increases to either an index like CPI or the rate of inflation. So what an employee's actual wage is going to be depends on what the index or the rate of inflation is at the time. And this was very popular back in the 70s and 80s. And we're now seeing it creep in, particularly, at least in my experience, in some of the public sector. So we're going to look at a few case studies right now of just some notable settlements over the last year to kind of give some context and some examples for what we've been seeing. So the first one is WestJet. WestJet and the AMFA, who is the union that represents about 655 aircraft mechanics and aircraft inspectors, reached a settlement earlier this year over the Canada Day long weekend after a 2-day strike that canceled hundreds of flights in one of WestJet's busiest weekends of the year to kick off to the summer season. This was an example, again, where there was a tentative agreement that was put before members in May, and it was rejected by almost 100%. We're looking at 97.25% of the bargaining unit. This resulted in difficult negotiations and dueling applications at the Canada Industrial Relations Board throughout June. And that's another thing to highlight. And one of the things that comes up in this example and the next example is that a lot of bargaining has resulted in more labor board practice. I'm dealing with situations, whether I'm involved with bargaining or assisting in the background, where we're seeing more labor board applications, either for failure to bargain in good faith or for unfair labor practices. Unions are using tactically different mechanisms to try to exert an advantage. And this goes for both cases, for employees and employers. But one thing that's happening a lot when deals are difficult to come by is parties are fighting more before the board. In this case, when the negotiations looked like they were at a standstill, the Minister of Labour referred the parties to binding arbitration on June 27th. And Ian's going to talk about this a little bit more when we look at government government intervention. But one of the things that came out of this was that even though there was a referral to arbitration, the board held that referral did not suspend the union's right to strike. And so after that referral, when the parties were getting ready to go to a mediation, the union commenced their strike, and they were on strike for 2 days, and a deal was reached 2 days later. And what we see in that deal is a lot of what we're talking about. We have a 5-year agreement. There's total increases of almost 26.25% over the life of the agreement, and there was a big first-year lift of up to 15%. And one other notable item was that there was increased overtime that's now at 1.75% instead of the usual 1.5 times, which we normally see in Alberta. The next example is the Coast Mountain Bus Company. So the Coast Mountain Bus Company, for those who don't live in Vancouver, operates all of the buses for TransLink, and they also operate the C buses. And in this case, they were in negotiations with CUPE, who was representing about 180 supervisors. And this was a settlement that was reached in February of last year. In this case, bargaining had been going on for a long time, since 2022. And we also had another strike with supervisors going on strike in January. And there was a complete shutdown again of bus and C bus services. So we're looking again at an instance where the union, where their ability to strike has the ability to completely shut down the employer's business. In this case, the employees returned after a special mediator was appointed. And the parties ultimately reached their agreement based on the recommendations of the mediator. But one thing I'll just note again, there were multiple board applications in this case for improper use of replacement workers, as well as essential services applications. In this case, we have a shorter agreement of 3 years, but it was retroactive, and total increases were between 13 to 25%. And just to note, that is estimated. We haven't seen the actual settlement, but we know that the employer was pushing for increases of 13%, and the union was looking for increases of 25%. So there was something in that range. And I'll pass it back over to Karine.
Yes, the Old Port of Montreal case. There was a collective bargaining ongoing over a year. Previous contract in 2021 ended with special return to work legislation, if you remember. I think it's been 15 years that the Old Port of Montreal hasn't had a negotiated contract without any intervention of government or arbitrator. So it's been difficult labor relation for a long time that we can all read in the media. So there was a mediation, and after 35 sessions over 50 months of negotiation and a expired CBA, that was not any negotiation that was working. I have a chart here of the conflict and negotiation. So as you can see, starting in October of this year, there was a first 3-day partial strike, and then a refuse to do overtime, and then another 1-day strike, and then another partial strike. So after all of these bumps of and surprises, the employer decided in November to go on a lockout. And I'm not an insider here that I know the information, but my gut said that is telling me that they decided to go on a lockout because they kind of knew that the government would intervene immediately. And instead of being surprised by the union and all those mini strikes and threats, a few days later, on November 12th, there was an imposition of a binding arbitration to force a return to work. So it's kind of back to the usual with those parties, and there will be another set of negotiation, arbitration, and mediation to try to resolve that conflict. So this was one of the major negotiation coming in Quebec last year. The other one is the case of all the Montreal and a lot of Quebec hotel. There were a lot of labor disputes. As you might remember, there were a lot of hotels all unionized with the CSN in Quebec, and they decided to do negotiation altogether with the purpose of going on strike altogether if it was not working. The demands for the wages raise were very, very high, 36% wage increase over 4 years. The hotels said in a lot of media interviews that they could not keep up with those wages increases. Therefore, there was a lot of multiple strikes and lockouts started in July at the beginning of the summer up and until November. Over 46 sessions of negotiation and a lot of negotiation and discussion. As of November 20th, a couple of weeks ago, 17 out of the 30 hotels reached an agreement, but the conflict was still going on at the Fairmont Queen Elizabeth Hotel that are now in a lockout for a long time. There's a lot of other industries that are going on disputes or a long negotiation history in Quebec. Those are just two examples. Back to you, Ian.
And so I'm going to comment on first Air Canada and the situation that happened with their pilots earlier this year. This was something that was in the news quite a bit. So by way of background, Air Canada had been coming off a long period of labor relations peace. And this was in large part due to very lengthy collective agreements that were entered into starting in around 2014. With the pilots, for example, there were 10-year agreements negotiated at the time. And there were significant and lengthy contracts also entered into with the other main unions at the airline. And the reports at the time was the idea here was to create an environment of stability and peace that would allow the airline to recover from some of the past challenges it had had due to the economic and other circumstances early in the 2000s, but to also grow and become an even greater player in the worldwide airline industry. And so that met with, the strategy seems to have met with some success for all involved as the airline grew exponentially over this period, growing jobs, expanding the scope of its operations, mostly internationally. And so we have this situation where, and these, while they were 10-year contracts, they weren't really 10-year contracts. They had reopeners set along the way where there was opportunities to adjust and bring issues forward and adjust terms every couple of years. As specifically as it relates to the pilots, for many years, the pilots at Air Canada, the over 5,000 of them now, were represented by the Air Canada Pilots Association. A few years ago, they were taken over by a different union, an American-based union called the Airlines Pilots Association. ALPA, as it's referred to on this slide, now represents most unionized pilots across Canada at all the major carriers. And so ALPA's taken over, and as any new union coming in on the scene, they had to demonstrate their worth to their members. Obviously, when a new union comes in, it's because there's likely criticisms about how the prior union had conducted themselves, and that was consistent with what happened in this case, based on the public reports. And so there was a situation where the new union's in, they didn't like anything that happened in the past. The complaints that came forward were mostly about, we've fallen way behind over this long 10-year deal. That was not the right play from the union's perspective. They were comparing themselves to many settlements that had been done in the U.S. airline sector, Delta being one of them, United, and they were saying, we're not being paid nearly as much. And so they came to negotiations loaded for bear. And so negotiations for the pilots commenced when the 10-year agreement was actually terminated 1 year early. Negotiations started in around the summer of 2023 and went on for 14 or 15 months. And all that was discussed during that time was non-monetary items. They didn't even get to the money, which is all the stuff that got into the paper. But the Air Canada Pilots Collective Agreement is not simple. It is volume upon volume. It's very thick and it's very dense, as one would expect given the nature of the industry. And they spent months in mediation and extensive periods of time trying to negotiate all of these non-monetary or quasi-monetary issues. And agreement was reached on a great many of items, but they weren't able to settle it all. And so that's brought us to a situation where, despite having spent many months in focused negotiation with one of the leading mediators in the country, and continuing to meet and doing all of the stuff that you would expect to happen in a major negotiation of this kind, they were still quite a distance apart, it would appear, in the lead up to a potential work stoppage in and around mid-September. Now, it would thanks to the hard work of all involved, they were able to get a deal done, and they were able to do it just prior to when Air Canada was going to have to start canceling flights and to do this. So in this case, it wasn't actually when the strike deadline had occurred. Under the Canada Labour Code, which governs Air Canada, each party has to give 72 advance hours notice of its intention to either strike or lock out. And in this case, once either that notice had been given, because you can't have planes spread all across the world, and there's a whole bunch of operational concerns where you can't have things out there. Operations were going to have to start to wind down as soon as that notice was given. So the settlement was done on the eve of that 72 hours notice. The key elements of the deal was a 4-year deal with some retroactivity going back to the expiry of the collective agreement in September of 2023. Total increases of 41.7% over the life of the agreement, and average first-year increases of 26%. Now, those are noteworthy terms. There's a whole host of other agreement items that I'm sure were agreed to as well, but these were the ones that sort of got publicly reported and seem to have caught people's attention. Now, it should be noted that despite what appears on the surface to be quite a generous contract, there was still a very significant number of members of the pilots union who voted against this offer. 35%, thinking it was not nearly enough. And despite all of this, it still wasn't good enough. And it would seem that some of the concerns had to do with work-life balance and scheduling and other concerns. So despite the fact that you're able to put together what appears on the surface to be a very generous deal, there is still a sense amongst some in the industry that it wasn't, or some people within the union, that it wasn't good enough despite all of this. And so in the years ahead, there's a settlement been reached in this case, but other Air Canada unions are now lining up for their turn to negotiate new collective agreements for themselves. The next one in line is QP, which represents the flight attendants, and their contract is set to expire at the end of March 2025. So I'll Another one, and if you want to get people's attention with a labor dispute, try and cut off their liquor in the middle of the summer. And that's what happened here in Ontario this past summer. The Liquor Control Board of Ontario, their contract was up for renewal, and there was a strike. The strike went on for about 2 weeks. Now, while wages and monetary increases are always important, this is an example where there are other important structural issues that were at play in negotiations. The Ontario government has signaled, the current Ontario government has signaled a desire to move away from exclusive selling of alcohol at the LCBO and is looking to make more types of wine, beer, and ready-to-mix drinks available at grocery stores, retail outlets like Costco, and convenience stores. And this is of concern to many of the folks that work at the LCBO because of the loss of the monopoly and the effect it could have on future job security. And so one of the major disputes at this issue was a fight about the government policy itself. And proposals being advanced, which would seem to try and touch on or at least restrain the ability for certain government policies to be implemented. And this is not unique. The facts here are no different than in other industries where the world we're living in now being very different than in the past. Things are changing. The economy is changing. Structural changes are occurring which are making jobs that used to be quite safe and secure less secure in the new economy. And people are looking for ways at the bargaining table to try, on the union side, to provide protections for the workforce, and on the employer's side to make the changes they feel are necessary to be able to survive in the modern economy. And so this was one of those disputes. And what was interesting here is the union went out on strike. You know, they're concerned about job security and among many other issues. And on the first day of the strike, the Premier of Ontario put a video out there providing a map showing where everybody could go to buy alcohol at places other than the LCBO. And then shortly after that, within a matter of a few days, there was an announcement where they actually accelerated the date by which alcohol could be sold in certain grocery outlets, which started in the late summer. And now, as of today's date, there are now you can get a broader range of products in grocery stores, in sort of large retailing outlets like a Costco, as well as in convenience stores in various locations. So there's real sea change there. So, the result of all this was after a 2-week strike as a settlement was reached, wage increases 8% over 3 years. So sort of at the lower end of the ranges we've been talking about, based on the averages we went through earlier. There were lots of protections, however, built into this settlement that would address union concerns about job security, about store closures, and about the conversion of formerly part-time individuals or casual employees into permanent part-time employees. So a balance was struck and a settlement was done. But, it's not dissimilar from the dispute that's currently, or it seemed to be going on right now with Canada Post. According to public reports, one of the main issues in that discussion is about how to position Canada Post to compete with parcel delivery and how to make it be able to survive in a world in which the amount of mail that is being sent, traditional mail, is decreasing to the point where it's going to make it difficult for the organization to survive. And so it's not only wage settlements or those key monetary terms that are causing challenges at the bargaining table today. There are these structural issues that parties are required to confront as well. So this really just sort of summarizes, hopefully, or it acts as a little bit of a summary of sort of the concepts, but these are all the concerns and issues that people are facing as we're going through. So I don't know that there's a need to sort of focus too much on that. But perhaps what we'll do now is transition into talking a little bit about government intervention. And so many governments, our federal government and many of the provincial governments across our fair country, have made a point of adopting pro-worker policies. And this seems to be true regardless of the political stripe. There are parts of Western Canada where there's still what we would have recognized as a conservative political party in days past. But in Central and Eastern Canada, even those parties that used to call themselves conservative have now all adopted pro-worker sort of positions. Nobody wants to be seen as the enemy of the blue-collar worker or of the unionized workforce, and so everybody's trying to position themselves to find favor with that group. That's certainly true at the federal level, and certainly true in Ontario and many other provincial jurisdictions. And so we have a situation that when there are significant work stoppages or threatened work stoppages in major industries that are vital to the Canadian economy, governments are now being caught in a little bit of a box. How is it that we address this issue? And so what we're seeing is, well, they continue to profess their their total preference and love for all things about free collective bargaining. They're looking for tools and ways to protect the public interest and to ensure that the interests are balanced in the appropriate fashion. And so historically, how this would be done would be through back to work legislation. But back to work legislation isn't what it used to be and is much harder to get and is now subject to much higher levels of court scrutiny. And so what they're starting to do is look for new and additional tools in order to intervene in potential disputes and to end potential disputes. And so we're at an inflection point in where this is all brand new. And so we're going to give you a little bit of context on where things are. We're not going to be able to tell you where things are going to land because we're still in the crisis of figuring this all out. But it's certainly important to note, and we think these are trends that are going to affect your bargaining at all levels, regardless of whether you're subject to the federal laws or provincial laws or sectors. So a little bit about back to work legislation more broadly. So the law in this area remains very unsettled. There were a series of Supreme Court decisions about 10 years ago now, which enshrine the right to collectively bargaining as being a right that is protected in the Charter, and that required governments or put governments to the test. If you're going to issue legislation that ends a work stoppage, you're going to have to demonstrate that you've balanced interest and you've taken these important Charter considerations into account. And so in the aftermath of these important decisions, back to work legislation in many jurisdictions across the country was routinely challenged in court and eventually struck down. Unions were successful in securing decisions that put great restrictions on how, if, and when governments were able to intervene in back to work legislation. And they've been on a winning streak. Every case seemed to sort of tighten the noose a little bit more and make things more challenging for the government. So in 2024, we saw a number of very important decisions issued in this area. The first decision, the ATU, this has to do with legislation relating to the TTC in Toronto. There was an Ontario Court of Appeal decision, and this continued the trend of decisions where certain regimes that were decided to restrict a party's ability to freely collective bargain through the traditional bargaining process was restricted and found to be unlawful. But there was some, I call it room for optimism, or perhaps a slight return to sanity in two decisions that were released in July of 2024. They're both Ontario Superior Court decisions, but in both of these decisions, interventions made by the government through back to work legislation were found to be justifiable and reasonable. And there's quite lengthy analysis in these cases, which stands essentially for the proposition that governments can't be going around doing this willy-nilly, but there are certain circumstances in which it will and should be justifiable for governments to say, we can't let the parties take everybody else down with the ship. There's a certain point in time when we're going to need to intervene. You need to be careful and you need to make sure it's done in a principled way, but it is permissible provided certain factors were met. And so were two decisions there in relative quick succession, which sort of buck the trend a little bit. But this is also uncertain. Those two decisions have been appealed. They're going to the Court of Appeal, and we expect decisions within the coming year. And so, the current state of the law will probably have a lot more to talk about on back to work legislation at next year's session. And I say all that really to sort of lead into what I'm about to say next. It's in that backdrop that we've seen some quite extraordinary things from the federal government. I'm going to start off by talking a little bit about freight rail and then talk a little bit about airlines, and then we'll talk about the ports in that order. So both of the Class 1 freight railways that underpin so much of the Canadian economy, CN and CPKC, were both had their contract with with both their largest unions, the union representing locomotive engineers and conductors, the actual operators of the trains. Their contract had come to an end at the end of last year. They were negotiating, and there was a potential work stoppage deadline set for, I think it was around May 22nd or 23rd, somewhere in there. About 12 or 13 days before the deadline, the government out of nowhere issues what's referred to as an essential services referral, where the minister stepped in and says, well, I'm not satisfied. I think there could be a danger to the health, life, and safety of Canadians if these railways go out on strike. And so I'm going to send this matter to the Canada Industrial Relations Board for an inquiry. Now, the parties in this case had already both reviewed the essential services and come to an agreement that it wasn't engaged. There had been prior decisions from the Labour Board in prior rail disputes that had confirmed that the standards, the very high standards required to be met to be essential services for purposes of this very specific provision of the Canada Labour Code wouldn't be met. But nonetheless, off to the Canada Industrial Relations Board, the parties had to go, where there was a several-month inquiry conducted before a decision was ultimately released, confirming that the essential services standard under the code wasn't met on August the 9th. So why is this important? Well, while this analysis is being done, the Canada Labour Code says nobody can go out on strike. And so by issuing this referral, the government effectively kicked the can down the road. And so one of the ways they decided to try and deal with this potential work stoppage was to issue this referral, an essential services referral. Now, the one thing the government did accomplish, and this is truly a tremendous feat, is in a world where the union representing the locomotive engineers and conductors in the railways, sometimes don't get along. This was the first time when they were all united in their outrage against the government. They'd all been planning and working towards a deadline, and they were working towards that, and then they had the rug pulled out from under them all with 12 days before the deadline, which threw supply chains and everybody into a whole bunch of turmoil for a period. So I'll come back to what happened next after this in a second, but while this was happening at the Labour Board, Andrew provided the excellent description of the WestJet dispute that happened. In this case, though, the government didn't use the essential services referral. They used a provision of the Canada Labour Code, Section 107, which provides the Minister of Labour with broad and fairly unfettered discretion to do anything the minister thinks might help resolve industrial disputes. And so the minister used the powers under this provision to refer the dispute involving WestJet and its mechanics to bargaining in the hopes that that would end the strike. Okay. And the Minister of Labour at the time went on social media extolling the fact that the strike had been ended, the referral had been issued, and all would be well in the world, only to a few hours later have to take that post down, realizing that the government hadn't done it properly. And instead of issuing a referral that said, I'm ending the strike, ordering people back to work, and referring things to interest arbitration, they only said the last point. And so when it went to the Labour Board for implementation, the Labour Board said, well, yeah, we'll refer it to interest arbitration. We're happy to do that. But there's nothing in here that says the strike has to end. So union, this interest arbitration process could take weeks or months. Union, you're on strike until then if you want. It's not affected. And so that was the government in that case had tried to intervene, but hadn't done it successfully, at least according to what they said their goals were in some of their public postings and social media posts, and so that sort of left a lot of people with a little bit of a bad taste in their mouth about that situation. Now, for completely unrelated reasons, the Minister of Labour resigned several weeks later and was replaced by a new Minister of Labour, who was in place by the time we get to until we get to later in the summer, in August, when both railways are back. The essential services proceeding has now been resolved, and now there's another strike deadline. and both operations cease at both railways, and when no settlement could be reached as of midnight on August the 22nd. And so once again, the minister resorted to a referral under Section 107 of the Canada Labour Code. In this instance, the referral was much more specific, having learned from the mistakes made in the past, and the guidance provided by the decisions issued by the Canada Industrial Relations Board. The referrals in these cases were a little more specific, and specifically required everybody to return to work, for the existing collective agreements to be continued, and for any remaining issues in dispute to be resolved through interest arbitration. Now, the unions do not, involved in this case, have objected to the manner in which the minister exercised his discretion under Section 107. They tried to challenge it at the Labour Board before the back-to-work order was actually implemented, and they were unsuccessful in that endeavor, but appeals have been filed and are currently before the Federal Court of Canada, and this is one of many pieces of legislation challenging the way in which the government is currently intervening in labor disputes under Section 107 that are going to be the matter of litigation over the next number of months. So Section 107, having been obscure and not relied on as often in the past, all of a sudden was a hot topic. We'd seen it at WestJet in July. We'd seen it at in the railways in August, and in September, despite the fact that ALPA and Air Canada were successfully able to achieve a negotiated settlement, there was rumblings in the air about 107, and there's rumors in the labor relations community, would it be invoked, would it not be invoked, nobody knows, but it was there again as a prospect of what might happen. And so it wasn't used there, but it has been used in the month of November. So Karine mentioned the dispute going on at the Port of Montreal. The tool that the government used to refer the matter to interest arbitration was Section 107. They didn't just do it at the Port of Montreal. The ports of Vancouver and in Quebec City were also out, and they issued 3 referrals at the same time, saying that it was impossible for the Canadian economy to continue. I'm paraphrasing, but there was too much challenges. We can't have all our ports shut down by labor disputes all at once. And then there was individual considerations taken into account. And so back to work orders were then an issue. So again, not through back to work legislation, but through Sections 107 of the Canada Labour Code. Now, the unions are challenging the constitutionality and the appropriateness of these referrals. One of the referrals involving the ports out in Vancouver the challenge is currently before the Canada Industrial Relations Board, and there's a hearing scheduled for next Monday and Tuesday. There are other challenges involving the other ports that are making their way through various processes, including at least one at the federal court. And so again, there's a lot of litigation on this. Is this going to become the new norm? Is it the current exception given the current political environment? How is this all going to play out? I can't, I have my personal views that I will not share at this point in time. I think we will wait for the courts to weigh in, and there'll be more on this to say, I suspect, next year. So, but the important thing that I think drives home, that we need to drive home there is in the world in which we're operating right now, with supply chains being so interconnected and everybody being so integrated, a strike at one location can have in these large industries and these large employers can have a massive effect across the entire economy that takes on a scale and a public importance that needs to be managed in some way. And so the debate that is going to be engaged in, whether it be in the courts or a discussion between the courts and the legislature with legislative changes or whatever it's going to be, is going to be how are we going to manage that? Because while people talk a lot about respecting the right, freedom to bargain and whatever, when people start having their services interrupted, there's not as much patience within large segments of the population, and the governments are trying to figure out how to balance economic concerns, national reputation, important international trading relationships, safety and security for citizens, and the many other important considerations that can come into play. So, with that, I think we're going to move ahead now and start talking a little bit about what we see in terms of things to be on the lookout for in 2025. Andrew, I'll turn it over to you.
Okay. Thanks, Ian. So in addition to waiting for some very important and hopefully very interesting litigation that's going to come out of the federal use of their powers under 107, there are a few other things that we just want to highlight that are going to be coming into play this year and that are going to have an effect on collective bargaining. And the first is the ongoing trend towards banning replacement workers. So before this year, there are only two jurisdictions that had bans on replacement workers during strikes or lockouts, and that was BC and Quebec. We now have new bans coming into force, one already in force in Manitoba and one coming into force for federally regulated workplaces. And so this is going to have an effect in bargaining because it's going to have an effect with contingency planning. It's going to have an effect when you're determining what your leverage points are, and it's going to have an effect in determining how you're going to be able to operate your business if you're looking at strikes or lockouts. So as mentioned, the federal bill that's going to ban replacement workers for federally regulated industries is going to come into force on June 20th, 2025. And this ban's going to restrict an employer from using a number of different classes of workers from performing bargaining work during a strike or lockout. So this replacement worker ban is similar to what's currently in place in British Columbia right now. And it restricts an employer from using the following kind of classes of different workers if these individuals have been hired after notice to bargain was given. So that's something important to remember. The threshold for determining what workers can perform what work is when notice to bargain was given. And that's something to be aware of because sometimes notice to bargain was it can be given well in advance of when any work stoppage actually occurs. But that's what the legislation requires as the trigger point. So in this case, we're under the federal legislation, we're looking at prohibitions against using employees, using individuals who perform management functions who don't normally perform bargaining work, any contractors, employees whose normal workplace is a workplace other than where the strike or lockout is taking place. So that means sending work that would be done at one site to another site for other workers to perform. Any employee that's transferred to that workplace where the strike or lockout is taking place, there should be a space there, but any volunteer student or member of the public, essentially you can't give the work to someone who's not, quote, an employee or a contractor. And then employees of employers. So we're talking about agency workers. There are some limited exceptions. The first is pre-existing contractors, provided that they were already providing the same work before the notice for strike or lockout was given. So essentially it's a status quo. You can continue to use contractors for the purpose of which they were performing, but you can't give them any further or greater amounts of bargaining unit work. The next is replacement workers can be used if there's imminent danger or harm to people or property. So if there's an emergency, replacement workers can be used to manage the situation. However, you must first give union workers the opportunity, the bargaining unit members, the opportunity to perform that work prior to engaging replacement workers. And it's important to note that there are some significant fines that are placed in the legislation of up to $100,000 per day for employers who violate this. And again, because this is new legislation, we're not sure the extent to which the board, the CIRB, is going to be using fines or the extent to which they're going to exercise their discretion. But this is a very heavy penalty that's included in the legislation. One thing, another change that's happened with the introduction of the ban on replacement workers is that the parties, the union and the employer, have to enter into a maintenance of activities agreement. And a maintenance of activities agreement essentially is an agreement that sets out activities which are necessary to ensure that services or that the public can be safe and that no services will be provided in any way that's going to cause a risk or danger to the public. So the parties have to get together, and this is an important change. They have to meet within 15 days, or just meet, excuse me. They have to come to an agreement within 15 days of when notice to bargaining is commenced. And if the parties identify any steps that need to be taken to protect the public from threats or danger or harm, an agreement has to be entered into, which will set out how those are going to be managed. And that agreement could even be an agreement that says there is no activities that have to be maintained. But no matter what, an agreement has to be entered into. And if the parties don't reach an agreement, then it could be a referral to the board, who will determine the maintenance of activities issues. And the board, the act says that the board has to make that decision now no later than 82 days after receiving the application or a referral from the minister. So in this case, one of the consequential changes is that a union or an employer cannot have a work stoppage until a maintenance of activities agreement has been entered into and filed, or the board has reached a determination on those issues. And we've seen the same thing come into effect this year in Manitoba. Just on November 7th, last month, there were a number of changes to the Labor Relations Code in Manitoba. One specifically prohibiting replacement workers, but also something to flag, which is slightly outside the scope of this presentation, is that Manitoba now has card check certification. So there's the ability to have immediate certification if 50% of employees sign union cards. In terms of the prohibiting replacement workers, the ban is going to be very similar to what's in the federal code, the new federal changes, and what's in BC. Again, there's not going to be the ability to hire any employees to give work to any employees or contractors or transferred employees if they were hired or engaged after notice to bargain was given. There's still limited exceptions, similarly, for threats to life, health, safety, or property. Unlike the federal code, there is no provision for maintenance of activities. However, there is the ability to get essential service designation. And this is like we have in British Columbia, where if there are threats to the safety, security of the public or employees, the parties can seek an essential services designation. And while this has been in place for a while in British Columbia, up until last month in Manitoba, essential services designations were only available to certain government sectors and healthcare. It's now available to any industry. And so it's going to be something that parties will be able to consider to seek essential services agreements or orders in order to maintain activities in the case of a work stoppage. And when looking at replacement workers, we're having some data on the effects of these replacement worker bans, specifically in British Columbia. BC has prohibited replacement workers for a long time. It's been decades now that provision has been in there. But we've seen a huge jump in the last year of unfair labor practice complaints based on the use of replacement workers. We only have the data from 2023 based on the board's annual report, but there were 30 unfair labor practice complaints filed for the improper use of replacement workers that year, which is far in excess of what we saw in 2002, 2001. 2020 was, of course, an outlier because of the pandemic. But even prior to that, generally you had between 4 to 8 complaints a year. We've now seen 30. And this jump likely has to do with the number of work stoppages that we're seeing. Obviously, with more work stoppages, there's going to be more instances where there could be a breach of the replacement worker ban or complaints made by unions. But it's clearly going to be having effect in how these work stoppages are dealt with. And as we see this being introduced to the federal space and in Manitoba, and I'm sure the experience in Quebec is very similar, this is causing additional litigation and more things that employers have to consider when doing their contingency planning. And one thing that's also come up in British Columbia is what the scope of replacement worker bans are. There's been recent decisions in BC where the board prohibited an employer from using workers in another province to to do work which the board found was the work of employees in that province, so in British Columbia. And so in that case, they expanded the scope of the interpretation of the code to outside of British Columbia to other workplaces in other provinces. And that decision's being actively appealed and is going to be going before the Court of Appeal in the next year. But if the BC board is taking that type of interpretation of the scope of replacement worker bans, it's possible that the Manitoba board and the federal board could take a similar view and have an outsized effect, not just on the use of replacement workers within a province or a jurisdiction, but in the entire country. Something else that we're seeing in developments is amendments in BC to permitted picketing. Recently, up till this year, there was a decision that had been reached a couple of years ago, which said that unionized workers were only able to refuse to cross picket lines if they were permitted by the BC code. So in this case, in Vancouver shipyards, there was a question of whether provincial unionized workers had to cross picket lines to go work at the ports where the federal workers were on strike. And in that case, the BC board held that their interpretation of the code was that a unionized worker is only able to refuse to cross a picket line that was permitted by the code. So in that case, narrowing the scope or interpreting it to only be a provincially regulated strike. This year, the legislation has changed that, or in order to now to expand the definition of strike to be any picketing conducted by an employee that's regulated by the laws of Canada or another province. So as of this year, provincially unionized workers in BC can refuse to cross picket lines in federally regulated workplaces such as the ports, telecommunications, and transportation. One of the next trends that we want to identify when we're looking ahead is going to be the effect of immigration challenges. There is a labor shortage in Canada, and there's always a question of how do we find people? And when we can't find people, what that normally does is has an effect of increasing wages. And so there are a number of immigration challenges that we've seen this year. One, Canada implemented a cap on the number of students that it was going to take for 2024 and going forward. There were certain changes that Immigration Canada made to end temporary public policy allowing visitors to apply for work permits from within Canada. Now they have to return to their home jurisdictions and apply. And we also have changes with the government pausing the temporary foreign worker program for low wage stream, which is resulting in a restriction against certain employers applying for temporary foreign worker program permits if the metropolitan area where they're based has an unemployment rate of over 6%. And in addition, they're not allowed to use more than 10% of their total workforce through temporary foreign worker programs. And so we have a number of restrictions that are through these new immigration rules, which are shrinking the potential workforce that employers can hire. And so these issues are going to come up when we look at pressures on wages and how wages may increase. And it also is work status immigration issues are being raised in bargaining as well. One thing that we've been seeing, this is more on the organizing side, but one thing I've been dealing with when dealing with organizing campaigns is unions reaching out to new populations and new Canadians or Canadian permanent residences or visitors, saying that they're able to assist with immigration issues, and if they sign a union card, they're going to be able to help with these things and help appeal to this idea that they're going to enable workers to be able to stay in Canada. And so while I have specific views on the appropriateness of that and what the mechanisms are, it's clearly being an issue that's coming up to the force. So the unions are taking on these immigration issues and raising them in organizing and in bargaining. And so this highlights, again, the importance of contingency planning. we've already looked at most deals are going to be obtained very close to the deadline. There's not going to be a lot of time at the end to figure out what your contingency planning is. This has to be considered in advance of bargaining, we'd suggest, and reevaluated throughout. And we know that even if we think there's not going to be an issue, we have a good sense of the market, we know we're going to be giving some reasonable wage increases, there's no guarantee that it's going to be accepted. And so we're going to have to be prepared. And what's happening is we're seeing more and longer strikes. We saw in the data earlier of the number of hours that are being lost. It's something that we have to be prepared for. In lots of circumstances, you're not going to be able to go into bargaining just expecting that a deal is going to get done. And so being prepared is now more important than ever. And so now Ian's going to address some technological changes.
Just to pick up on Andrew's last point before we move on, contingency planning is a very difficult thing because often the changes that are needed to properly plan to weather a work stoppage are things that can't be done in a week or a month, but take years and future planning. And so we're seeing trends where people are understanding that the trends we're talking to you about these presentations, they don't show any sign of waning. In fact, all of these things point to a direction where the balance is being shifted more in favor of unions. And I don't see that reversing in the short term. And so what I think people are doing is they're realizing going into a period where this isn't going to be a 1-year thing or a 2-year thing. It could go up and down and ebb and flow, and who knows what the future will hold. But we need to start planning ahead, not just for this round of bargaining, but how we're going to sustain ourselves well into the future. And going through that exercise in a real rigorous way at or near the start of the bargaining process can really help to inform not only your bargaining strategy, but can help to make sure that all the stakeholders in the negotiation are fully aware of both the opportunities but also the risks involved with whatever bargaining strategy you pursue, so that you have complete and total understanding and buy-in from the beginning. There's nothing worse than being at the bargaining table following a strategy to have it questioned or undercut by folks who are maybe joining the process late and don't have a full understanding for the full context. So educating people about the reality in which you're bargaining in and how that may differ from what people may have been used to in the past is an incredibly important part of the process. So that segue aside, I'll now turn to technological changes. We're starting to see issues relating to AI pop up in bargaining. How it's popping up is different in every industry, but it's the hot topic these days. It's only going to continue to increase, especially as it has the effect of maybe changing the nature of the work that some people are doing, especially in clerical, semi-clerical, or even in some professional roles. So it's something to keep. I don't think that we're able to point to any definitive trends, or it's not, as of yet, but it's sort of something that everybody's talking about more broadly, and it's making its way to the bargaining table as well. I think technological changes or the security of bargaining unit jobs is something that is likely to be a topic in 2025 because of the uncertainty we're going to deal with international trade. Threats of tariffs and other sorts of things throwing shockwaves through many supply chains, workforces and industries that have designed to be reliant on international partners. To the extent those relationships are strained or cut off completely, could have a dramatic effect and is going to start to cause concerns of the sort of a different sort than we've maybe had to deal with in the past. The push to globalization seems to be on temporary pause, and who knows where the new normal will be. But these are going to be important issues that are going to be of concern to both the employees that work for you and their representatives. And then there's just the world is changing, technology is increasing. So one of the main sticking points in the negotiations at the BC ports, we understand, has to do with what technology can be used to load and unload cargo from ships. I spoke about the situation at Canada Post earlier, where they're trying to make a difficult transition from being primarily a mail service provider to being something that can compete in a world in which there's less mail being moved. These are all technological or societal changes that are being met. They're only going to continue. So we think these issues are going to come to the fore even more in 2025. So what we thought we'd do now is try and give you some tips and tricks that'll help you close the deal and avoid all the nonsense and nastiness that we've been talking about for the last little bit. So I'll turn it over to Karine for that.
Yes, thank you. Time to take notes because all is not in the slide. So a few tips and tricks. One thing that is not on the slide is maybe be creative would be my best advice. Try to, for instance, if you are in a factory, try to think about new attractive schedules. I've seen employers going up with new trends in terms of schedule by weekend shift, work 24-hour, paid 32, or fixed 36-hour, paid 40. So people, instead of having rotation shift, they have fixed 12-hour shift, paid a little bit more than the 36 hours. So employers have been creative in terms of offering new way of seeing schedules to retain and attract new employees. In terms of signing bonus, I'm sure you all know what this, and you might have used it in the past. A new trend that could be creative is not just signing the bonus at the signature, but it could be also to get a bonus as a retention after the anniversary of the first year of the contract. So you sign the contract. If you're an employee at the signature, you're still an employee after the first year of the contract, you get X dollar. If you're still an employee at signature and at second year of the contract, you get Z XX dollar. Therefore, you, instead of having more salary or wages increases, you can get a flat amount by staying with the company. So it has been a solution that can work, and it promises some flat fee amount at the anniversary of the collective agreement. Signing bonus can be also a good solution instead of a long retroactivity or a complicated calculation of retroactivity. And if your collective agreement has been expired months, maybe years ago, you can decide to offer a flat fee amount for retroactivity, and the new salary will start at the signature. So union are open to those solutions if it's well explained and sold to them. Staggering of some concession that you're ready to do. I try to delay some of the costs in my negotiation, and when employees are ready to maybe say yes the first year, I'll say, why won't you say yes in the second year or the third year or even at the end of the fifth year? So union will know they get that new items and new working condition at some point, but it doesn't have to be all at the first year when you get all those costs and retroactivity sometimes to pay. So keep in mind that you can delay some concession in the future. Also, try to bring the union to the table by discussing problems and finding together solutions. I believe in roundtables where the employer or the union, they just don't bring some text to the table and try to convince you with this comma and that sentence and those words. Instead, I rather try to convince union to discuss problems, and we all come to the table and discuss solution. I've been impressed by how this can work if obviously everybody is in good faith to the process and really try to find solution. And then when we get a solution agreed with the union, we work on the text, and it's much easier to find solution altogether. I also want to raise the consideration of interest arbitration, and I will leave that to Ian maybe at the end of that list because I think he wants to address that solution. Tips before negotiation. We mentioned earlier the importance of being prepared. It's more than important. If you do have demands and you either that's monetary or non-monetary, you need to have arguments. You need to have facts. Why you need that concession from the union? Why you need that new whatever schedule? The union will always ask you why you need that. Is there a problem? Did we get a problem? And if you have no argument, no problem, no reason why you're just asking something, you will have a problem convincing the union. And even if your argument is harmonization with your other contract or other employee or other facilities, it is an argument, the harmonization that the union can listen to if it's well presented. And the union will really be listening if you do prepare like a couple of slide a presentation, and here is the present schedule. Here is the problem with that schedule with security or emergency or whatever. And this is a few proposed new schedule that we thought about, and that could have this pros and cons, and we wanted to discuss it. Every PowerPoint we do present in a negotiation, we have a very well response from the union by thank you for your presentation. We now understand and we appreciate that you take the time to build that presentation and those arguments. And so all preparation, it will pay out at the end, I promise. If your labor relations are bad or not good, or it's difficult, it's been difficult the last couple of years or last couple of months, it's very important to work on your labor relation before, prior the negotiation. It's really not the time at the negotiation to rebuild the trust. Then if you have to, you will, but if you can, slowly work on it prior the negotiation. And if your upcoming negotiation is 2025, 2026, you have the time to try it. I don't know about all the provinces, but in Quebec, we do have the Ministry of Labor with a very good service to help parties to get better labor relation prior or after negotiation. If you had a very difficult dispute, you can use also that service to get help into building new relation. If your labor relations are good, then good for you. But if you do have a few grievances, some union or some employers say, will settle their grievances in negotiation. This is not a good idea. You want to concentrate on your problems and your solution, and you do not want to go and discuss specific problems of grievances and 10,000 for that one and 500 for that one. So you rather have all grievances settle prior negotiation. If you have time, you have good relation, try to do some extra labor relation committee to try to settle as much grievances in advance. Looking at my notes to see if I have other tricks that I wanted to highlight. And I think I'm done. Ian, maybe you want to touch base with the arbitration.
Yeah, sure. Well, I'll turn it over to Andrew in a second, but just a couple of other tips that may be helpful. When you're looking at having to give very significant wage increases because you have to catch up or other sort of circumstances, consider whether it's the opportunity to not just give a standard, everybody gets the same increase, but whether it's time to rebuild the grid. Over years, wage grids can get out of whack. Certain positions go away. The reason technological changes or duty changes has resulted in one position not being as onerous as it used to be. When you're making not normal, when you're making very significant wage increases, can you use it as an opportunity to clean up your wage grid and to create a compensation system that's fair, better, and more balanced going forward? For jurisdictions where you've got pay equity obligations, this is an excellent opportunity for you to be able to try and ensure that your grid is pay equity compliant and that you're not creating increases that could give rise to pay gaps or potential future liability down the road. In situations, tip number 2 that I'd offer is in situations where you've got challenging bargaining, where you've perhaps got a union bargaining committee whose expectations are way out of whack. There's going to be a need to at least try to give them a reality check at some point in the process. You want to be thoughtful and mindful as to when you give them that reality check. Increasingly, if you can do that a little bit earlier in the process, leaving some time afterwards to rebuild the trust and to sort of push forward towards the ultimate goal, which is a negotiated deal, maybe that's something that's important, whereas before maybe you were trying to clean everything else up. But just be mindful about, if you're going to have some difficult discussions, when do you want to have them in bargaining, and do you want to leave them all right to the end when you're up against a deadline, or do you want to try and stagger them out a little bit earlier in the process? And if you can make sure that people clearly understand what your position is and the basis for it earlier on, hopefully then you can refer back to it, point back to it, and use it as a lynch, as sort of a point on which you can continually refer back to, which can be effective. And the final thing I would raise is these trends that we're talking about mean that union negotiators are often in difficult spots. They're being asked to try and get everything for everybody. And oftentimes having to put proposals forward they know are objectively challenging for the employers. Have some sympathy for them, understand the plight they're in, and see if there's things you can do to make their life easier and to allow them to achieve what they need to do in a way that's constructive and that is not going to be necessarily adverse. So sometimes it's the silly little things, but looking at it from the other side and understanding where they're at and finding out, we need to get there. How do we do this? What can I do to create an environment where we're more likely to have success? Recognizing the position the other side's in and figuring out, are there things we can do within reason to make that easier, is something that can both build goodwill and lead to productive outcomes. Andrew, do you have anything you'd like to?
Final word.
Yeah. Sure. The only other thing I'll add to build on those tips is, when you're going into your bargaining, you're going to have to manage your own internal expectations from your own stakeholders. What we've seen here is, again, that don't expect bargaining to go as it has before. There's been a lot of changes. There's going to be a lot of different pressures. And so managing your expectations about how the process is going to go will help you open up the various stakeholders to thinking about things in a more creative and maybe a more different way, like Karine and like Ian's been saying. Sometimes to get to the point where you're preemptively thinking about changing a wage grid or putting in some different structure, it's not something that everyone's going to want to do on the company side, because, well, let's just see what we can do like we've done it before, and let's just try to get a deal. Again, we have to understand that bargaining is harder these days, and managing your own internal expectations will help you open the doors to see things and review things in a way that maybe those opportunities weren't otherwise going to be present.
We're right up against the end of our allotted time, so we did receive a couple of questions. I will perhaps we'll try and address them in about the next 60 to 90 seconds, and then we will wrap up. A question was raised about the press for longer settlements and where that comes from. Essentially, I'm going to paraphrase, but are the longer settlements a result of retroactivity or some other consideration? I can handle that one and just say, no, unions know that right now the going rate is 3, 4, 5, 6%, whatever the increases are. If they can lock that higher percentage in going forward and do it for a longer period of time, they're well aware of the fact that in 2 or 3 years, inflation's not likely to be where it's at right now. Wage increases are going to go down. So they're looking to crystallize the increases for as long as they can going forward, in addition to whatever retroactive compensation is owed. So where in the old days, we'd be trying to get extended deals to avoid having to negotiate, and we knew we'd have to pay a little bit more for it. Now they're open to saying, well, we'll do a little bit longer, but we want a premium of you having to negotiate in the current environment, as opposed to waiting a couple years, where I think everybody's of the view that wage settlements are likely to be slightly lower than they are right now. In terms of another question, or was there anything else that anybody else would like to add before we go on to our last question?
Nope.
working from home and working from home policies and remote policies. And the question was like the scope of an employer's right and what happens when people try and move extended distances away from the office, and how that plays into any of that. Would anybody like to field that question?
Sure. I can talk about it quickly. So, those are good questions, and we're having a lot of challenges and struggle with that right now, determining, what exactly the employer's right is. So in the context of when we're dealing with the unionized environment here, the scope of the employer's right is going to be what's reasonable. Any policy that's going to affect workplace conditions is going to depend on whether or not it's reasonable and a reasonable application of management rights. And so unfortunately, what's reasonable is going to depend on all of the circumstances. But one thing to be aware of is when you don't have an agreement over a specific work from home policy or a specific remote working policy, still there is the ability to, what's reasonable is going to depend on what the needs of the company is. And there's going to be a presumption that employers are required to come into the office to work in most cases. That's the presumption you're starting with. And so requiring that is generally upheld unless there are compelling reasons or unless there's an ability such as a collective agreement or a remote work policy that's going to allow employees the right to work remotely.
We seem to have come to the end of our allotted time. So first of all, we'd like to thank you all for your attention. We hope that you found today's session to be helpful and or interesting. We would once again encourage you to take a moment to fill out and provide us with feedback by filling out the surveys that are provided under the survey tab. Today's session has been accredited for continuing education credits with a number of different organizations. The HRPA code can be found below. Ontario and Quebec, there's CPT accreditation, and there's information in the chat about how you can use this session for credits in British Columbia. Thank you to my fellow panelists, and we look forward to seeing you again at one of our future sessions. Thank you and have a good rest of the day.